Welcome back, dear students. Today we will understand the concept of right to life and personal liberty as enshrined in Article 21 of Constitution of India. Article 21 dealing with protection of life and personal liberty is a very small article with a larger ramification. Article 21 says that no person shall be deprived of his life or personal liberty except according to procedure established by law. There are two rights contained in this article. One is right to life, and second is personal liberty. So, no person shall be deprived of his life or personal liberty unless there is a procedure established by law. This Article 21, dear students, is couched in a negative language and it confers on every person the fundamental right to life and personal liberty, which has become an inexhaustible source of many other rights. These rights are available to citizens of India as well as to the foreigners. I have highlighted the word person. The word person here indicates that this fundamental right is available to citizens of India and equally to foreigners also. If a foreigner comes to our country, he or she deserves protection of life and personal liberty because our constitution guarantees this right to every person, not only to the citizen but to every person. And the word person is wide enough to include persons other than citizens. Truly speaking, dear students, Article 21 is the procedural Magna Carta for protection of life and liberty, and this right has been rightly held to be the heart of the Constitution, the most organic and progressive provision in our living Constitution. Article 21 can only be claimed when a person is deprived of his life or personal liberty by the state, as defined in Article 12. Violation of the right by private individuals is not within the purview of Article 21. It is the state invasion of personal life and liberty which is protected by Article 21. As I told you in the earlier part of this lecture, that Article 21 secures two rights. One is right to life and second is right to personal liberty. This Article 21 prohibits the deprivation of the above rights except according to procedure established by law. That's why I called Article 21 as Magna Carta of all the liberties or Magna Carta of 1215. It corresponds to Magna Carta of 1215, the Fifth Amendment to the American Constitution. Dear students, Article 21 applies to natural persons also. The right is available to any person, citizen or alien. Thus, even a foreigner can claim this right in India. Now, what is the meaning and concept of right to life? Life in Article 21 is not merely the physical act of breathing. If I am breathing, I am speaking, I am alive, I have life. It does not connote mere animal existence or continued hard and boring life. It has a much wider meaning, which includes right to live with human dignity, right to livelihood, right to health, right to pollution-free air, etc. So many other rights are included in the right to life. We have a leading case decided by Supreme Court in 1963 Khadak Singh versus State of Uttar Pradesh, in which Supreme Court held that by the term life, as here used, something more is meant than mere animal existence. The inhibition against its deprivation extends to all those limbs and faculties by which life is enjoyed. The provision equally prohibits the mutilation of the body by amputation of the armored leg, or pulling out of an eye, or destruction of any other organ of the body through which the soul communicates with outer world. And in next important case, Sunil Batra versus Delhi administration, Supreme Court reiterated and held that right to life includes right to lead a healthy life so as to enjoy all faculties of a human body in their prime conditions. And it would include the right to protection of a person's tradition, culture, heritage, and all that gives meaning to a man's life. It includes right to live in peace, right to sleep in peace, and right to health also. Then in Maneka Gandhi versus Union of India, the Supreme Court gave a new dimension to Article 21 and held that right to live is not merely a physical right, but it includes within its ambit the right to live with human dignity. Human dignity is also part of right to life. And elaborating the same view, again, Supreme Court in Francis Corali versus Union Territory of Delhi observed that the right to live includes right to live with human dignity and all that goes along with it. That is, the bare necessities of life, such as adequate nutrition, is part of life, clothing, shelter over the head, and facilities for reading, writing, and expressing oneself in diverse forms, freely moving about and mixing and mingling with fellow human beings. And it must include the right to basic necessities of life and also the right to carry on functions and activities as constitute the bare minimum expression of human self. So this is the scope, you see, ramification of right to life, that it includes right to live with human dignity. Another aspect of right to life is to be found in another ratio decidendi of the Supreme Court in Bandhua Mukti Morcha versus Union of India, in which the Supreme Court said that Article 21 is the heart of fundamental rights. The court gave it an expanded interpretation, and Honorable Justice Bhagwati observed in this case that it is the fundamental right of everyone in this country to live with human dignity, free from exploitation. Then in People's Union for Democratic Rights versus Union of India, Supreme Court held that non-payment of minimum wages to the workers employed in various Asiad projects in Delhi was a denial to them of their right to live with basic human dignity and was violative of Article 21 of Constitution of India. You know, Asian Games were held in Delhi and so many constructions were undertaken and thousands of labor was employed in those construction works, but even minimum wages were not paid to them. So non-payment of minimum wages amounts to denial of right to life, and which is violative of Article 21. Then comes another important case for your understanding, that is State of Maharashtra versus Chandrapan. In this case, Supreme Court struck down a provision of Bombay Civil Services Rules 1959, which provided for payment of a nominal subsistence allowance of ₹1 per month to a suspended government servant upon his conviction during the pendency of his appeal as unconstitutional on the ground that it was violative of Article 21. Dear students, you know that if a public servant commits misconduct, an inquiry is instituted against him besides the criminal offense under any other law for the time being in force. So during the conduct of that inquiry, the public servant is sometimes suspended from his duties and he is paid generally half of the salary as basic subsistence allowance during the pendency of the inquiry. But here the Bombay Civil Services Rules 1959 says that a suspended government servant will be provided a subsistence allowance of ₹1 per month. So this ₹1 per month is ridiculous, and Supreme Court says that during pendency of appeal, if you are paying only ₹1 per month to a suspended government servant, it is violative of Article 21 of Constitution of India. Nobody can survive in ₹1 per month. So this meager amount, little amount of ₹1 per month goes against the concept of right to life as enshrined in Article 21. Then you see Supreme Court decided another very important case which dealt with right against sexual harassment at workplace, especially for the ladies. So this right that there should be no sexual harassment of ladies at workplace is also a part of right to life. The name of the case is Shakha versus State of Rajasthan. Here Supreme Court declared sexual harassment of a working woman at her workplace as amounting to violation of gender equality and right to life and liberty, which is a clear violation of Article 14, 15 and 21 of Constitution of India. In this landmark judgment, Supreme Court, in the absence of enacted law to provide for effective enforcement of basic human rights of gender equality and guarantee against sexual harassment, laid down certain guidelines for the protection of the women. And later on, those guidelines were converted into shape of a law. So this right given to the ladies that there should be no sexual harassment at workplace is also a part of life. If a woman or a girl is being sexually harassed at her workplace, it definitely affects the right to life of the ladies. Then ladies have another right against rape. Why they should be raped? If a female is raped, she loses her right to life. She starts living like an animal after the rape. So Supreme Court in Bodhisattva Gautam versus Subra Chakraborty observed that rape is not only a crime against the person of a woman, it is a crime against entire society. It destroys the entire psychology of a woman and pushes her into deep emotional crisis. Rape is therefore the most hated crime. It is a crime against basic human rights and is also violative of victims' most cherished of the fundamental rights, namely the right to life with human dignity contained in Article 21. The moment woman is raped, her dignity is lost. It affects her right to life and it affects her life very badly. So right against rape is also part of right to life. Then right to livelihood. Roti, kapda aur makan. Roti, kapda aur makan. Food, shelter and clothing are also part of right to life. In Olga Telis versus Bombay Municipal Corporation, popularly known as Pavement Dwellers case, a 5 judges bench of the Supreme Court held that right to livelihood is born out of right to life, as no person can live without the means of living. That is the means of livelihood. In this case, the Bombay Municipal Corporation removed the pavement dwellers from the payment. Their entire establishments were rooted out. It affected their means of livelihood because some of them were doing small petty business while living on the pavements, and they were removed from those pavements. So ultimately, it affects their means of livelihood, which is part of right to their life. Then comes right to shelter. Chameli Singh versus State of UP. 3 judges bench of Supreme Court had considered and held that right to shelter is a fundamental right available to every citizen, and it was read into Article 21 of the Constitution as encompassing within its ambit the right to shelter to make the right to life more meaningful. Right to life is meaningful if I don't have the shelter to live, is the spirit of this case. Then comes right to social security and protection of my family. Right to life covers within its ambit the right to social security and protection of family. The leading case is Calcutta Electricity Supply Corporation India Limited versus Subhash Chandra Bose. It was held in this case that right to social and economic justice is a fundamental right under Article 21. Supreme Court explained that right to life and dignity of a person and status without means were cosmetic rights. Socio-economic rights were therefore basic aspirations for meaning of the right to life, and that right to social security and the protection of family were integral part of right to life. If I am not able to protect my family, if the state is not providing protection to my family, then right to life has no meaning. If state cannot provide me social security, right to life has no meaning. So right to social security and protection of family is part of my right to life. Then there is another latest fashion, honor killing. If a boy and girl run away from home and they marry each other, especially when they belongs to different castes, then when they come back, the parents kill both of them. Boy as well as girl, both are killed just to save their honor. Honor of the parents. So that honor killing goes against the right to life of that boy and girl who has been killed. So Division Bench of Allahabad High Court in 2002. The name of the case is Surjit Kumar versus State of UP. Allahabad High Court took serious note on the harassment, ill treatment and killing of a person who was a major for wanting to get married to a person of another caste or community, for bringing dishonor to the family, since intercaste or intercommunity marriage was not prohibited in law. The Allahabad High Court said that such practice of honor killing was a blot on the society. So court therefore directed the police to take strong measures against those who committed such honor killing. So honor killing is basically against the right to life, because you are taking away the life of boy and a girl. Obviously it is offending Article 21, which protects right to life as well as personal liberty. Then dear students, right to health is also part of right to life. The name of the case is State of Punjab versus MS Chawla. It has been held that right to life guaranteed under Article 21 includes within its ambit the right to health and medical care. So right to health is also part of right to life. Similar is the case with right to medical care. Right to health, right to medical care are interconnected. So I have a right to medical care as part of right to my life. The leading authority is again Parmanand Katara versus Union of India. Supreme Court has very specifically clarified that expression preservation of life is of the paramount importance. Supreme Court stated that once life is lost, status quo ante cannot be restored. If a man is dead, you cannot revive him. So it was held that it is the professional obligation of all the doctors. They may be private doctors, they may be government servants, to extend medical aid to the injured person immediately to preserve life without legal formalities to be complied with the police. Generally, the scene is that doctor says that it is a medico-legal case. Report at the police station first, bring copy of the FIR, then they will start treatment of the patient. Supreme Court says no. Right to life. Once the life is lost, it cannot be revived. If you will wait for police action, the patient may die. So the patient has a right to life. He has a right to immediate medical care. You cannot say that I am a private doctor and I will not give first aid to the injured. You will have to give first aid to the injured person. So government doctors, private doctors, all are obliged to give immediate treatment to the injured person because he has a right to medical care as part of right to life. Then dear students, whether right to life includes right to die? Probably not. Article 21 confers on a person the right to live a dignified life. Does it also confers a right not to live or right to die? If a person chooses to end his life? If so, then what is the fate of section 309 IPC, which punishes a person of attempting to commit suicide? There are two cases. The first one is Piratiya Nam versus Union of India. In this case, Supreme Court took cognizance of the relationship or contradiction between section 309 IPC and article 21 and held that right to life embodied in article 21 also includes in it right not to live a forced life to his detriment, disadvantage, or disliking. And in this case, section 303 IPC was declared as unconstitutional because section 303 IPC provides the death penalty as the only penalty. Then this ruling was reviewed in Gyan Kaur versus State of Punjab. The question before the court was that if the principal offense of attempting to commit suicide has been declared unconstitutional or void, then how abatement of suicide, which is punishable under section 306 IPC, can stand? When the principal offense is not an offense, then how abatement of suicide can be an offense? So the court overruled the decision of division bench in Piratiya Nam's case and has put an end to the controversy and ruled that Article 21 is a provision guaranteeing the protection of life and liberty, and by no stretch of imagination, extinction of life be read into right to life. And this is the reason that section 303 IPC was held to be constitutional. Previously, in Piratiya Nam, it was held as unconstitutional. Then ruling was overruled in Gyan Kaur. Now it is constitutional. That means you can award death penalty in suitable cases under section 303 because you are providing this death penalty in accordance with procedure established by law. You are not killing one ill killing anyone like honor killing. It is a killing according to procedure established by law. Suppose a person undergoing life imprisonment has committed murder again. So only punishment provided in 303 is death. So you are awarding death penalty to a person after due trial. That is in accordance with procedure established by law. Then, dear students, right to life also includes right to get pollution-free water and air. This was decided in Subhash Kumar versus State of Bihar by the Supreme Court once again. It was held that right to live is a fundamental right under Article 21, and it includes the right of enjoyment of pollution-free water and air for full enjoyment of life. If anything endangers or impairs that quality of life in derogation of laws, a citizen has a right to have recourse to Article 32 of the Constitution for removing the pollution of water or air which may be detrimental to the quality of life. So, dear students, this right to life is so wide that it includes pollution-free water. I have a right to get pollution-free water and pollution-free air. Then connected with it is right to clean environment. This was held by the Supreme Court in MC Mehta versus Union of India. It was observed that right to life under Article 21 means a life of dignity to live in a proper environment, free from danger of diseases and infections, maintenance of health, preservation of sanitation and environment have been held to fall within the purview of Article 21. Clean environment, I have a right. I have a right to life. Corona-free life is also part of right to life. It is a duty of the state to control coronavirus, to provide vaccine, to provide hospitals, to provide medicines for control of corona. Because the right to clean environment is part of my right to life. Then again came right to noise pollution is my right to life or part of it. The case is before the Supreme Court in noise pollution. This case was regarding noise pollution caused by obnoxious level of noise due to bursting of crackers during Diwali. The apex court suggested to desist from bursting and making use of such noise-making crackers. Supreme Court said that no firecrackers will be bursted between 10 p.m. and 6 a.m. in the morning, so that noise pollution may be reduced, so that obnoxious gases pollution may be reduced. And why? Because I have a right against noise pollution as part of my right to life. Then, dear students, I have right to know, right to be informed as part of my right to life. The leading case is Reliance Petrochemicals Limited versus Proprietors of Indian Express newspaper. In this case, Supreme Court ruled that the citizens who had been made responsible to protect environment had a right to know the government proposal, what government is going to do for the protection of environment. Right to know was recognized as necessary ingredient of participatory democracy. So right to know or right to be informed is also part of my fundamental right to life and liberty. So dear students, this is in nutshell the meaning of right to life as enshrined in Article 21 of Constitution of India. So thank you very much, dear students.